Hello, welcome all. Good evening. I am CA Mayuri Jaga, moderator of this webinar, and we are delighted to welcome you all in this webinar, which is being organized by the Committee on Commercial Laws, Economic Advisory, and NPO Cooperatives of ICI. It's my pleasure to be a moderator in Know Your Law Series 43, which is webinar on arbitration and RERA, interplay issues and solutions, recent case laws on 4th January 24 from 4 p.m. to 6 p.m., which is being organized by CCLEA and NPO of ICI. In a short while, we will start this webinar, and I would like to apprise you about this committee. This committee is focused on to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multi-functional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker will talk on arbitration, RERA, interplay issues and solutions, and recent case laws in this webinar, and we hope that the same will be useful or shall be useful to the members. I welcome our eminent speaker, CA Nipun Singhvi sir, and I would brief about sir and about his profile. CA Nipun Singhvi sir is a practicing advocate, and he is also FCA CS LLB LLM in cooperative laws, certified forensic IFRS bank auditor, qualified independent director, Ministry of Corporate Affairs, executive program on merger and acquisition in IIM Ahmedabad, and he is a qualified insolvency professional examination IBBI. He have been member of the World Bank Insolvency Group on Train the Trainers jointly with IBBI and IPA of all the three institutions, that is ICI, ICSI, and ICAMI. Research paper which is selected by IIM Ahmedabad and IBBI, published on Anusandhan 2022 on sale of company under liquidation as a going concern. And he have been appointed by NCLT for convening meetings as chairman in disputed cases of operation and mismanagement. He's an expert member of various committees of ICI on cooperative laws, bank audit, accounting standards. He has been a chairman on cooperative law committees and GIPA Avoidance Transaction Committee of ICI IPA. He's a resource person on certification of on MSME and IBC, and he has published various articles and WIRC reference manual on insolvency laws and insolvency and bankruptcy code examination. He has been awarded by Divya Bhaskar, Dainik Bhaskar Group for excellent contribution in real estate justice in 2021. Deliver more than 1,600 lectures on various laws and across 70 cities. He has been regular faculty at IC and ICSI, nationalized banks, CNAG, and trade associations, and regular authors for various corporate tax journals, majorly in Taxman. Corporate professionals, and today he is in Economic Times, Dainik Bhaskar, the Chartered Accountant General, the Resolution Professional, ICI, Triple IPA, Tax Guru, TaxScan, Live Law, IBCLaws.com, Financial Express, panelist for debates, shows on Z Business. He has been invited for various university, National Law University, NLU Jodhpur, Patiala, Gandhinagar, Ahmedabad, Udaipur, and Hyderabad. He has been trainer for All India Legal Credit Recovery Debt Officer of Bank of Baroda and SBI, and regulators such as Gujarat RERA and Kerala RERA. Expert on corporate, commercial, and insolvency laws, and handled 650 cases in insolvency. He has been financial activist, social activist, and RTI activist. I welcome sir, and I welcome Nipun Joshi sir. And I wonder why you have written a short profile in this because you have such a long profile. And I'm just great to have you as our speaker. And I just want to listen from you about this. RERA and its issues, interplays, and arbitration.
Thank you very much, Mayuri ji, and thank you, committee, for inviting me to host on a very interesting topic. In fact, this topic is so important in today's world because this our own committee has also been doing the course on ADR, and RERA and ADR is something now very intertwined because of the latest developments. And many of our fellow chartered accountants have become panel members to act as an arbitrator. So this is a new opportunity for all of us. And apart from our traditional practice, this particular area can be explored to the best extent, because nowadays new areas are more better for chartered accountants rather than traditional practices. And such type of area where an expert advice is required, I think we are the most apt professionals who can do this. I'm also being joined by my colleague, Mr. Madhe Billa, who is also a chartered accountant and an advocate. So we both would be deliberating upon topic today. It's a very interesting topic because I will be discussing on arbitration as well as RERA. We all know that RERA has hardly been 6 years into existence. And in these 6 years, numerous judgments have been delivered by Honorable Apex Court, which have been traveling from authority till Supreme Court, because this became a special law and it helped other laws, remedies to be weeded out easily. Before this law, we had Consumer Protection Act, we had civil court matters, but all those were taking too much time to get disposed of. In fact, sometimes we were at the mercy of those resourceful persons who were either builders or developers. And once they took the money, they would never return the money and also did not give possessions on time. So, this particular law has helped us to get a quicker remedy and a better forum. So, practically speaking, and I have been appearing in almost at least half a dozen of RERA authorities across India, and have been seeing how the RERA has taken shape. It's a very small law. Practically, I tell you, it's a very thin book. You can just read it and understand it. If 10% of efforts which we give otherwise in Income Tax Act could be given in this law, I think we all could master this law. Because the law is very straightforward in a very simple language, and it is made for the convenience of the home buyers. So ultimately, it was a law which was for the customers, though during the various parliamentary committees and changes in draft, today what we have, the law covers even the commercial property. So even if I take a commercial property, let's say a shop in a mall, and the builder is not delivering me, I can very well go to the RERA authority and ask for the release. So now this particular law is basically between builder and buyer. So I will put it very in simple words. Once the breach is there between the builder and buyer, as per the terms of contract which they decided, it is very easy to go to RERA authority, and the adjudication time, though normally it is suggested, it should be disposed of within 90 days, but anything between 6 months to 1 year is taken as an average time period or adjudication in getting the orders. Second most challenge, or I would say biggest challenge, is that once you get a RERA order, how to get the execution done. So execution of RERA order is also equivalent to a civil court decree. So for execution, you have to go to the appropriate court. Now, in some cases, some RERA authorities have taken the help of retired judges, retired district court judges, and endowed them with the power to execute the order. Some states have made amendments so that the execution can be done with the help of CPC provision, and those provisions can be captured in the RERA regulations and rules itself. So state government has power to notify the rules, and in case of absence of any specific rules, CPC can be borrowed out. So this is broadly what RERA law talks about with regard to complaints and with regard to orders. Now, issue comes, typical issue would arise when the RERA law is there as well as arbitration clause is also there in the agreement. I will also touch upon what will happen because our today's topic is, let's say the RERA is at the center. What will happen when there would be a contractual obligation and RERA? So there would be an interplay between RERA law and obviously the arbitration law. Sometimes it might happen that the RERA law would also interplay with other laws like Consumer Protection Act because of a customer may have filed a complaint under Consumer Protection Act and may also file complaint under RERA law. So it could be parallelly two complaints. It could be one complaint at one particular point of time and subsequently another complaint at another point of time, or some customers who were before the RERA got enforced. So sometimes it happens. So sometimes it happens that the agreements which were executed pre-RERA, that is, before notification of the RERA law came into force, agreements were executed. So subsequent to that, what should be done? So I would be discussing somewhat on the contractual obligation, pre-RERA, post-RERA, interplay of RERA with Consumer Protection Act, interplay of RERA with Insolvency and Bankruptcy Code, and also in cases where there are dispute between two co-promoters or two builders or buyers where they are part of the same company. So sometimes it could be a redevelopment issue. Sometimes it could be a tussle between two promoters, that could be landowner or the builder, or there are two different builder groups which have come together. Now, all those situations, how those things will be handled. So I'll just share my presentation. I hope it is visible, Mayuri.
Yes, it's visible.
Okay. So if you let us talk historically, why was the RERA brought into force? And very interestingly, you should read the object of the RERA as per the statement of object and reasons of the RERA Act. Now, RERA Act is basically an act to establish an authority. So you see the RERA is being regulated by an authority. Similarly, we have in capital markets SEBI. In case of banking industry, we have RBI. Similar to that, we have real estate authority. Now, what is that authority doing? They are regulating and promoting the real estate sector. Now, here you see what they're doing, regulating. What kind of regulation? To ensure sale of plot, apartment, or building, as the case may be, or sale of real estate project in efficient manner, transparent manner, protect interest of consumers. Now, please see these words. The law is basically that it is a pro-consumer law. It is with regard to sale, purchase of the property, and also that the person who is getting it is getting everything on time to protect the interest of the consumer. You will wonder if you read complete RERA Act, except this object and reasons, there is no mention of the word consumer. So in the object, they talk about consumer, but if you technically go and read the sections, the other side, the consumer is defined as an allottee. So real estate project, there would be an allottee. And who is an allottee? The allottee is a person who has a unit in the project. Suppose it is a bungalow scheme, it would be a bungalow. Suppose it's a apartment scheme, it could be a flat. So as the case may be, these all will be considered as customers. And here they also talk about establishment of an appellate tribunal. So this is the structure of RERA. Nowhere, if you read it, there is any mention of any other dispute resolution. It talks about authority, it talks about tribunal. But if you try to correlate it, that whether it tries to capture anything such as arbitration, conciliation, mediation. No, it's not there. It says there is an adjudicating mechanism. If you talk about law, authority will have some chairperson, members who will hear the complainants. That is mostly in case of RERA, the complainants would be allottee. And mostly the complaints would be number one, the project is not completed on time, the unit is not delivered on time, there is a delay in possession. Sometimes the sale deeds are executed and the physical possession is not given. Sometimes what will happen that after taking the possession, XYZ facilities is not there, lift is not there, club is not there, parking space is not there, something which is relating to common amenities. Sometimes it can also be the case where there are structural defects, the property is not in good condition. Now, all those issues have come out of the law of RERA. Now, who is going to be the aggrieved person? In 80-90% cases, the aggrieved person would be the allottee. Who is going to redress this particular issue? The builder is going to address the issue. Now, here, where I'm using the word loosely as builder, if you talk about RERA law, the word used is promoter. Now, or there are difference of opinion in the word promoter. Some of the state regulations and rules do not capture both the persons as promoter. So typically, right now, the model is a person may be a landowner and a person would come and say, I would be the developer and let's get into a joint venture agreement. Now, in this particular joint venture agreement, when two people are coming together, technically they both are promoters. But some states have taken the view, and again, this is an anomaly and will have to be resolved in the coming future. There is a anomaly that a landowner would say, I have given already my land to the developer, and it is the developer's duty to complete it on time. And sometimes we have also faced such a situation where landowner backs out from his joint venture agreement, whereas the money has already been paid by the home buyer. So in those situations also, real estate authority steps in. However, that is not an issue today. Today, the issue is what kind of disputes are there and how they could be settled. And settlement of disputes by a court order is there in RERA. Our target today is to understand how these disputes can be resolved in alternative form. So what we popularly call alternative dispute redressal, it could be by way of arbitration, it could be by way of mediation, and now the Mediation Act is also into place. So mediation and conciliation are being used interchangeably. So arbitration, mediation, conciliation, and there is also one term called Lok Adalat. So as per Legal Service Act 1897, that is also a concept which is imbibed in the law. And I will come on to all those concepts of ADR. But what I wanted to tell you was some of the grievances under RERA are in typical nature, which may never be covered under the builder buyer agreement. So those practically will not come under ADR. So the disputes which are otherwise not part and parcel of an agreement, they will never come under the ambit of ADR. So by default, if builder and buyer has an agreement and they have a clause of arbitration, then only the dispute between both of them can come under ADR. So a dispute, let's say I have bought X flat from a reputed real estate company, let's say ABC Real Estate Company. Now, if ABC Real Estate Company does not deliver me on time, yes, invocation of arbitration under that agreement can be done. Suppose they delayed in giving me the possession, ADR can be done. Suppose I want to withdraw from the project because they are not completing as per the terms of the agreement, then also arbitration can be done. But suppose there is a dispute between the owner of the land and the developer. Now, that dispute cannot be referred to arbitration under the builder buyer agreement because he is never party or he has not accepted for arbitration or conciliation or whatever is the case. So let us move forward. Now, I'm comparing it with historical law. So arbitration and Consumer Protection Act. Now, if you see Consumer Protection Act, it is for the dispute settlement of consumers. So if the consumer has, let's say, bought a unit in a project, and again the builder does not give him on time the possession, or delays the possession, or there is a refund which is asked by the customer, or maybe some of the amenities are missing, or there could be mis-selling also, there could be misleading advertisement also. All these issues will be taken care by the Consumer Protection Act. Now the question which came before Supreme Court was whether a person is entitled to move for Consumer Protection Act as well as under RERA. Does RERA, being a specific law, will not override Consumer Protection Act? So the answer is, and obviously I will give you the citations once we come on to the case law section, but the view taken is by the Honorable Supreme Court and also various high courts now, that Consumer Protection Act is an additional remedy. It is in addition to any other law, and therefore Consumer Protection Act remedy will always be there. So Consumer Protection Act remedy will always be there, and Consumer Protection Act complaint pending will not bar the other person from going under RERA. I will come on to specific sections, but the broad view taken is this. And when the RERA law was not there, what was there? So Consumer Protection Act was defining goods and services. Now here, whenever we are discussing about a builder-buyer agreement, what is the buyer paying for? So he's paying for a unit. Now normally, what is the unit of? So unit is an undivided share in the land, or it could be a divided share in the land, plus the construction. So now if you are thinking of the income tax and GST concept, it would be a works contract. But as far as Consumer Protection Act is concerned, basically the builder was supposed to give you a constructed home, and therefore they were covered under the clause of service. So under Consumer Protection Act, if it was of any of the breaches which I discussed previously, it will fall under the deficiency of services, and the Consumer Protection Act would take its recourse. Now, under Consumer Protection Act, there is a provision that the parties can mediate. So, Consumer Protection Act, the authorities have the power to send the parties for mediation also. And there are also a provision of voluntary consumer association under the Consumer Protection Act, which obviously can take care of the interest of the consumer. Also, if you remember, and obviously I'm not giving a real estate example, but yes, there was a case of this famous Maggie noodles, wherein there was something which was found out by one of the authorities, that there was a particular chemical substance which was more, and pan India it was banned. The case under Consumer Protection Act was filed by Ministry, the Department of the Consumer Affairs, as a complainant on behalf of all the consumers across India, because some substance which was not appropriate to the health was found out. Obviously, ultimately, it was not accepted by the court. Ultimately, the matter got rejected. But the point I'm trying to tell you was, there was a class action suit also, where in a representative capacity, government itself could file a complaint. Now, such situations have arisen, and some of the RERA authorities also, just like under Consumer Protection Act, they could have told government authority to complete it. Some of the cases, and which I have come to know, like in the case of JP, in the case of Amrapali, where the authorities themselves have been directed by the court to take over the charge and complete the project. Sometimes even they have asked the government authorities to step in to complete, like they had asked NBCC in the case of JP Infra to step in and complete it because the company did not have funds. So such type of extraordinary power can be used just to give justice to the consumers. Now, let us come on to our topic today. What is this concept of arbitration, or I would say holistically the topic of alternative dispute resolution? So broadly speaking, we have these four categories of ADR, though recently now the Mediation Act has come in, which says that mediation and conciliation can be used interchangeably. But however, both of them are informal modes of resolution of dispute. Arbitration, I would say, is a standardized judicial format of resolving the dispute. And Lok Adalat is a form where both the parties agree and they get a judicial stamp on their understanding. Once there is a case resolved under Lok Adalat, no appeal can be done. However, in case of arbitration, appeal can always be done. Then again, in the case of mediation, if both the parties have agreed, then it is good. But if one of the party wants to object, then the mediation would fail. So conclusively, the out of all this, the most popular form of ADR, which has judicial blessings, is arbitration. This traces back to the history when there was an amendment and Section 89 was brought into CPC. Now, Section 89 of CPC always, and I refer to the Justice Ravindran book, wherein Justice Ravindran talks about alternative dispute resolution mechanism to deburden the courts to reduce the litigation. Sometimes what happens is when the court intervenes and court tells both the parties what worst can come, probably they might tell the petitioners they might lose, probably the respondents may not may lose their rights if the orders go haywire. So in those situations when pros and cons are told by the court and both the parties come into a consensus that it is better to close the matter than to go for the litigation, sometimes the parties agree to go for mediation. Now I will tell you one such example and one such instance which normally happens. Now all of our chartered accountants are there. You must have seen, let's take the example of NCLT. What happens is there would be a family run company, a typical family run company, brothers running together the company, or maybe father, son running together the company. And then the dispute arises. Dispute arises, obviously, there would be an allegation that I am being oppressed or there would be instances of mismanagement. Now, in such a case where both the parties are going to fight in the court, now minority would come and say to the court that the funds of the company should be freezed. Obviously, that would be the first prayer of any minority shareholder group. And suppose the court gives a stay on the use of funds from the company, you know what will happen to the business of the company? It will come to a standstill. Suppose it's a real estate company and there is a stay given by the court. Until the stay is there, no sale deeds can be done because you are into the business of selling the land. And if there is a stay, the complete inventory gets frozen and the circulation of money stops. So such could be the draconian steps taken. So here, now in this particular and typical situation, I'll not quote the name of the companies, but recently we were handling a case where joint venture parties were there in a real estate company. Two sets of people, they started fighting, and the worth of their project from 500 crores came down to 100 crores just because of their infighting. Getting stay on the funds to be utilized, stay on sale of the property, stay on sale of property to third party. All those stay was there, granted by different courts because of different complexity. They started fighting and valuation came down. And ultimately, when the both the sides were being told by the court that see what you have done to the company, the valuation has gone down and it will ultimately destroy the value of the company. So we both are fighting for something which ultimately because of our fight is already out. So then there will be no resolution in such a case. Now for this particular aspect, sometimes people feel and sometimes professionals like us would always advise the parties to go for mediation. Now, this example I gave you was of a companies act where the matter is before NCLT. So there under Companies Act, we have a specific section called 442, wherein you refer the parties to mediation. And there is a mediation panel, and you all participants can always go and get yourself empaneled for it. There are chartered accountants, company secretaries, then advocates who are also on the panel of this mediators, which is being maintained by Ministry of Corporate Affairs, which is regional director wise. So whatever is your jurisdiction, you can go and make an application. I think MDC1 is the form in which you can apply for empanelment, and MDC2 is the form where one of the parties can go and say that we want to go for mediation. And normally the court appoints a mediator out of the panel, whoever is available and willing to take up the matter. Now, this was a typical example wherein the mediation could kick in. Now, let us take an example. Can the court refer the parties to arbitration? Yes. If the court is made aware about the arbitration clause in the agreement between the parties, obviously the court would say that you go for arbitration, and that invocation can be done. But Section 89 also empowers the court to refer the parties to arbitration. Now, in that case, my view is, if you read the language of the Section 89, you will see that yes, the parties can be referred to arbitration. But in practical sense of the matters, until the clauses are there in an agreement and a formalized agreement is there, arbitration normally does not kick in. Because first, the arbitrator has to be agreed by both the parties. So if one party suggests one arbitrator and other party does not accept that arbitrator, what will happen? The matter will go to court under Section 11 before the High Court, and the High Court will only have the power to appoint any arbitrator. So that arbitration appointment is also a big challenge, where there is even a formalized agreement. So if there are no formalized agreements, then obviously the courts are not sending the matter to arbitration. This is again my practical experience. However, if you read Section 89, it can be sent. Why am I discussing Section 89? I am discussing Section 89 because if you read Section 35 of RERA law, there also the RERA authority has the power of a civil court. Though they are not bound by the strict provisions of CPC, but they exercise their power as a civil court under drawing the powers from CPC. So the CPC provisions can always be applied to RERA proceedings, and a via media can be found out to resolve the disputes. So this is all what is important with regard to Section 89. And I will just read out the section for the benefit of the participant. Where it appears to the court that there exist elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observation. And after receiving observation, court may reformulate the terms of a possible settlement and refer the same for arbitration, conciliation, judicial settlement, or mediation. So here the court has power, and that power is also in the nature of shall. So it's mandatory. So court can very well do it. Now you see, where a dispute has been referred for arbitration or conciliation, Arbitration Act would apply. To Lok Adalat, then LSA, Legal Service Authority Act would apply. Now comes the point whether, similar to this, if there is an arbitration, if there is RERA, in both the proceedings starts parallelly, what should be done? And this is very interesting. Now, you read Section 88 of RERA Act. It talks about application of other laws, not barred. Section 88 says the provision of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. Now you see, Section 88 is saying that when I am into force, so that means when RERA is into force, no other law would be barred from operation. So that means RERA is saying it runs parallelly with other laws. I gave you the example of Consumer Protection Act. it will run parallelly. When it will not run parallelly, that exception I will tell you in the coming slide. But for now, understand that RERA law is also going on, Consumer Protection Act is also going on, and now take it from me that arbitration is also going on. So let us think that parallelly 3-4 proceedings are going on. Now, whether RERA will say no, proceeding A will not be there, proceeding B will not be there, and only my proceedings will be there. So, the answer does not come here in section 88, but answer comes in section 89. Answer comes as if that the act, which is the RERA Act, shall have a superseding effect. So, normally, what we call notwithstanding section or the wife section, it says that the provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the timing in force. So that means if there is no contradiction, then RERA law will not override. But if there is a contradiction between RERA law and X law, then RERA law would override. I'll give you some examples how it happens. Now you see the provision of RERA, section 71, there is a provision which says a person who complain in respect of matter under section 12, 14, 18 and 19. So if there is a complaint made by in our case, let's say home buyer in any of these 4 sections, and a similar complaint is pending in consumer forum, what the law requires is withdraw the complaint pending before it and file an application before the adjudicating authority in RERA. So if my consumer complaint was already filed, now RERA has come into play, it has been notified. I have a choice that if these 4 section prayers I want to demand, that is basically for adjudication of amount of compensation, adjudication of interest, I can withdraw my complaint from Consumer Protection Act and give my complaint under RERA law to the adjudicating officer. Now you will ask me, sir, what about other section or some grievance which otherwise is not covered under RERA? So whether, let's say I have suffered mental harassment because at the time of selling, they have promised XYZ things which were not given to me. So my answer is under Consumer Protection Act and not under RERA. Because I told you RERA is very specific. So if there is a delay in giving possession, we have section. If there is delay in giving you the appropriate common amenities promised, yes, you have a remedy under RERA. If there is a structural defect under RERA, you have a remedy. So if there is a structural defect, definitely you can go under RERA. So all these remedies which otherwise are available under RERA, you can't go under consumer. But under consumer, you can go for those remedies which are not available under RERA. So some things could be like mental harassment, that I did not get something on time. Sometimes I have taken a loan from the bank and because of delay, the delayed interest which is paid by the builder is not sufficient to bear the interest cost of the bank. So all those things I can take into consideration. Sometimes I have seen the builder has not taken an NOC from their lender. Therefore, I could not get home loan on time. So all those issues, small issues which otherwise do not fall under RERA can definitely go under Consumer Protection Act. However, I have also seen in my practical experience that RERA also has the power. Just like I told you, they have power under section 35, they have power under 37. They can very well go beyond the provisions of RERA and even award you something more in the terms of cost, in the terms of interest. But that's a different thing. If they do not give us, then also we will have to go for consumer. But the point is, if the RERA authority has already given, then obviously you can't demand the same thing under consumer law. So this is the issue with regard to interplay of RERA in consumer. Now, third important question which always people ask, whether the proceedings before RERA can be interjected by proceedings of a civil court. So normally, when I need to get some remedy, in India we have a very simple, easy law, Civil Procedure Code. We will file a civil suit. The tort, any civil wrong, action can be taken before the court. That is the tort, and any civil court will entertain it. Now the question is, when you are going under RERA, or suppose the other side is very notorious, they have filed for some civil suit, whether RERA will interject, will come in the way or not. So section 79 of RERA clearly says no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which authority, adjudicating officer, or appellate tribunal is empowered by or under this act, and no injunction shall be granted by any court or authority in respect of action taken. So let me give you an example. Let's say I had make the payment for a unit. Sale deed was not done by the builder in my favor, and there was a dispute with the builder with regard to XYZ things may or may not be related to the transaction. Now that builder is trying to sell that particular unit to somebody else. So what will I do? I will go to RERA, file a complaint, and in the meantime, when the builder is aware, he will try to sell it off. So to stop him from selling, I will ask for an injunction by the RERA court. Now, once the injunction is granted by the RERA court, can the builder go in the civil court and challenge that injunction and say you vacate the injunction? So this particular section 79 helps us. He cannot go to the civil court. He has the only remedy before the RERA appellate tribunal. So this law is very structured so that people who try to play around cannot play around. So this is very important that civil court vis-a-vis RERA, RERA will have overriding power, RERA will have powers to take course, and civil courts cannot interject the proceedings. Another important question, and this is very important to be discussed because now comes the case when the agreement is executed before RERA. So you see, the RERA law, when it came into force, it was challenged by a variety of builders pan-India. And ultimately, the Supreme Court consolidated all the virus challenges and sent it to Bombay High Court for adjudication. And the famous case is of Nilkamal Realtors. So in the Nilkamal Realtors, I think all the possible challenges to the sections of the RERA was done. So it's a very detailed judgment. You can read it at your leisure. Point I am trying to tell you was the builders challenged the RERA laws, saying that one, there are already laws into place for the home buyers, like we have Consumer Protection Act. So RERA should not be brought into place. Second, that if the RERA comes in, what will happen to our pending transactions, pending cases? Everything we cannot be covered with the RERA because RERA cannot have a retrospective effect. So on and so forth were the challenges. In crux, what the court held was, let's see, RERA is a special law. When RERA comes in, it will hold the feet, and it may not be a retrospective law, but it is a retroactive law. So retroactive law means, let's say some remedy was open and that remedy is now available under RERA law. So that remedy automatically comes under RERA law. So if you remember just two slides before, I told you 12, 14, 18, 19 is the section under RERA where the remedy is there. If same remedy you had applied for Consumer Protection Act, you withdraw from there and come under RERA. So the point is, even if the RERA did not exist on a particular date, but subsequent to enactment, the alleged action is covered under RERA, the remedy under RERA would be available to the customer. So this is very, very important that the RERA law, even though it is not retrospective, so if suppose a project was made and all the inventory was sold, so RERA would not apply to that particular project. Okay, that project need not go and get registration. But suppose one of the allottees, let's say it was built up in 2015, closed in 2015, handed over to everybody. Now in 2018, somebody comes to know there is a structural defect and he wants to file a case. Whether that 5 year period would apply or not, would definitely apply because it's a retroactive law. After the enactment of law, if the remedy is covered, it can be taken before RERA authority. Now, you see, Consumer Protection Act also similar section is there. RERA also similar section is there. So RERA we have section 88, Consumer Protection we have section 100. So basically what they say is these laws are in addition to other laws and they are not in derogation of other law. So basically, if I am going for a remedy under one law, that will not bar me to invoke remedy under other law. So this is very, very important that RERA law and consumer protection law both can go parallelly. There is no prohibition that if I have invoked one law, other law cannot be invoked. In fact, the preamble of section 3 of the Consumer Protection Act says that it is a law which is in addition to any other law. So it will always be available. Practically speaking, my view is that once you go to RERA, you get a quicker and a faster relief than going to consumer laws because consumer forums, as we know, and Supreme Court has also reprimanded the legislature that why they are not appointing the judges. Judges are not there. There is a huge vacancy, huge backlog in consumer laws. Consumer forum, wherever you appear, we have seen there are adjournment given of six months together. So practically speaking, I do not favor to go before consumer forum. However, theoretically speaking, we can go for both of them.
Sir, there are two questions.
Please.
Yeah. First is it mandatory for RERA agreement to contain arbitration clause?
Okay. And second one?
Second is in case the buyer buys a property, that is land or building, from a person which is not registered in RERA, what is the consequences for the buyer?
Okay. So I will cover the first question in my judgment. This I am going to discuss whether arbitration clause can be there or not. Answer is it can be there. Whether it is mandatory to go for arbitration or not, that I will answer. So you'll have to go through some of the judgments and sequentially decide what to do. So suppose we are two partners. Let's say we see a firm, we have two partners. So we both are chartered accountants, and there is a dispute between us. In our partnership deed, suppose it is written that the matter, the dispute will be referred as per the provisions of Arbitration Act. So yes, if we do not agree on one arbitrator, and obviously we will not agree when there is a dispute, nobody agrees. So you go to court, get an arbitrator appointed, and then the arbitration process start. Now you see, very interestingly, does our institute say that if there is a dispute between two members, there has to be an arbitration? Nowhere. So, but this is not so in other cases. So, if I give you an example of Cotton Association of India, so all the traders who do trading in cotton, they are members of CAI. If there is a dispute between them, it is mandatory arbitration as per their bylaws, as per their panel of arbitrators. Now, let us take another example. Let's say there is a cricket association where all the state associations are also party. If there is a dispute between two associations, again there is an institutional arbitration as per the bylaws. Now, sometimes we are transacting parties. One party is in India, one party is, let's say, in US. And we write in our agreement that if there is a dispute, we will go by XYZ institutional arbitration. So that XYZ could be Singapore-based arbitration, SIC, Singapore International Arbitration Center. Sometimes we put it Dubai, DIAC, International Arbitration Center. So we actually give ourselves to a particular jurisdiction to a particular institution, to a particular arbitration which is being followed as per their bylaws, rules, regulations, whatever the case is. Similarly, if I am agreeing to something in an agreement, both the parties will go by that particular law. Now, the question comes whether the dispute between the parties is arbitrable or not. The first issue which we need to consider is whether the dispute amongst the two parties is arbitrable or not. So, can I, just for the sake of example, can I make an agreement with a person X that you please stole this particular jewelry from Z and give me? And then I say, if there is a dispute, then we will go for arbitration. So, something which is not legal, which is an illegal act, the agreement itself is void ab initio. There comes no question of arbitrability. So, arbitrability has to be decided on the facts of the case. So, Supreme Court, in a very landmark judgment, which is followed till date, in the matter of Afcons Infra versus Cherian Varki, famously called Afcon Infra case, says that if the suit is if the suit is representative suit which involve public interest, then all the parties can never be before the court, and then therefore cannot be arbitration. So just like I gave you the example of Maggie, that case falls under clause 1. It is not arbitrable. If there is a dispute between two groups to get a power in any association, club, societies, they cannot be arbitrable. So if I say that the election is conducted illegally and Mr. X has been chosen to the authority of president or secretary, I cannot arbitrate with that party. That has to be decided by the court of law. Now, suppose there are allegations of fraud. So I gave you the example of partners having a clause in the arbitration agreement. Now, one party says that the other side has committed a fraud. How they have committed the fraud? They have siphoned off the money from the partnership firm. Or I was not available and my partner did my forced signature and withdrew the money from the bank account. These allegations of fraud, fabrication, forgery cannot be arbitrable, can never be arbitrable, because it is an offense. It's a public offense. It is an offense against the state. When I am alleging fraud, sorry, though both the parties cannot decide and keep quiet if a fraud was done. So this is very important, that fraud, fabrication of document, forgery, all these things are not arbitrable. As I told you, an example of theft, it cannot be arbitrable. Murder, kidnap, these all things are not arbitrable. So if there is an offense which is not between the two parties, but it is for the public at large, in short, it is not arbitrable. So then what can be arbitrated? So here comes the answer to our problem. If there is a contract where money is involved, yes, one party has to pay, other party has to receive. If there is a contract of specific performance, yes. So I had asked one event management company that I want Mr. Bachchan to come and sing for me. Now, Mr. Amitabh Bachchan does not come and he says that now let us go for arbitration. Yes, we can go for arbitration, claim damages. We can also ask for specific performance. Suppose I have given some money as a token, but because the prices of land increase and now you do not want to give me the land, then I can go for arbitration and ask the arbitrator that I don't want money, I want the property only. Because the goods are in such a nature, they cannot be replaced. So specific performance has to be there. So such case can be specific performance. Then banker and customer, we day in and day out see this. Whenever there is a default committed by the borrower, nowadays when the bank gives them, or normally it happens more in NBFC, account becomes NPA. They immediately start arbitration, along with recovery under DRT follow, along with check bouncing if they have blank checks. So all these are arbitrable. whether builder or developer can enter into an agreement for arbitration of any dispute? Answer is yes, it is arbitrable. So now the question is whether I can do arbitration or not. Yes, you can go for arbitration. So my suggestion, but it is not a mandation, is that builder buyer agreement, whenever we are vetting or considering, try putting a clause for arbitration, because it is a quicker way of getting things done, efficient way of redressal. In fact, Madhevji is there. He will tell you how Maharashtra RERA has come up with a forum for conciliators. So, as far as RERA Act is concerned, Act does not talk about arbitration or conciliation. But Maharashtra RERA had brought out this concept of conciliatory mechanism, and they have been very successful. So Madhevji will start just I complete the judgment. Then he will tell us about what is the conciliatory way of doing things. So everything which is suitable for arbitration, like dispute between employers, employees, or member of society, like two members of society are disputing with regard to parking, with regard to usage of common amenities, they all are arbitrable. You can put a clause and get the arbitration done. Now, the question which was asked by one of the participants, so I'm giving you one citation of Bombay High Court. You can read it. There was an agreement before RERA. So let's say we signed an agreement in 2015. Okay, when there was no RERA. We both decided as a builder and buyer that we will go for arbitration if there is any dispute. Now in 2017, RERA came in, and in 2000, let's say 20, there comes a dispute which can be fallen under RERA category. It could be delay possession, it could be delay on amenities, it could be non-giving of possession. Whatever is the case, it is covered under RERA as far as the dispute redressal is concerned. Now, the builder invokes the clause of arbitration and gives the notice for appointment of arbitrator. Now, this is getting challenged by the customer. So this particular issue, whether arbitration can be done when the remedy is covered under RERA, goes to Bombay High Court, and this traveled to Supreme Court also and came back, and henceforth the crux of this case is that the pre-RERA there was a contract, there was a clause of arbitration, and in that arbitration, the arbitration was started, and one of the parties is not happy, they want to go for RERA. Answer is, see, once we have decided to go under arbitration as per the clauses of the agreement, then I cannot at that point of time think that tomorrow a law will come and I will go as per that law. So arbitration is valid, arbitration is enforceable, and proceeding of arbitration will go on without being impacted by the RERA. So if it is a pre-RERA agreement and arbitration clause is there, very well arbitration can continue. There is no problem. Now the other question would be, sir, post RERA, if I am putting a clause of arbitration, can I go for arbitration? Yes, you can very well go for arbitration. There is no problem because both the parties have known that RERA is there. Even then they want to go for alternative dispute resolution, which they have agreed upon when they signed the agreement. Because dispute will always arise after the agreement. So there is no problem, it can go. Now third question, sir, as per the agreement, let's say if there is a delay of possession, the rate of interest given by the builder or the developer is 5%. But as per RERA law, if I go under RERA, I will get, let's assuming 12%. Now, can I say after enactment of RERA, this agreement which is providing for only 5% interest is illegal? Or can I choose to take a better rate of interest? So this is something which is very, very tough to answer in one line, because suppose the parties are able to prove to the court that with open eyes, with free will, with consent, they were arriving at an agreement for a lesser rate of interest, then obviously the lesser rate of interest should prevail. But if one of the parties is able to prove that, sir, we were being coerced to sign this agreement and therefore statutory rate should apply, then answer is statute would apply. Because there is a concept of estoppel. Now, estoppel cannot be contrary to the statute. So there is no estoppel against the statute. So if the statute provides for something, then we both cannot agree contradictory to that statute until and unless both the parties have agreed. So suppose builder and buyer both have agreed to waive off the interest and let's say settled on a particular terms. Another home buyer cannot come and challenge that why you have settled at a lower rate, you should charge higher rate. Third party cannot come and challenge if both the parties have agreed. But if the parties involved in the dispute challenge it and say, no, we do not accept anything below the statutory limits or provisions, then that would be the statute would be the final answer. So no estoppel against statute would prevail, and therefore in such a situation, statutory provisions would have to be pressed into service. So Madhevji, will you like to take the conciliation part? Then we will conclude the judgments.
Yes, definitely. Yeah, good afternoon, everyone. Thank you. Thank you, Nipun bhai. Thank you, ICI. I think Nipunji has correctly said when he was going through with the object clause of the RERA, nothing is specified about the arbitration clause. And however, as per the provision of section 32, which gives some powers to the RERA authority, and under section G, subsection G of the section 32, there is a provision called that RERA authority shall, for a dispute, for a amicable solution, and to bring out the dispute with the amicable conciliation, they can form a conciliation forum. Now the question comes that how the conciliation forum will be, formation would be there. So the provision said that it would be there will be two parts. One would be from the association, that is a buyer association, and from one side will be the developer associations. So then there would be a conciliation forum, and how this conciliation forum would be constituted. So Maharashtra and UP RERA both has come up with the conciliation forum as per the provision of section 32 subsection G of the RERA Act. Now, what is the effect of this conciliation forum and how it proceeds? So if we see the statistic data of what is available as per the press release and everything, data retail, if you go into the MahaRERA, so the conciliation forum, there is a 50% acceptance on the conciliation forum where they can redress their grievances. So if suppose I am a promoter or I want to go before the conciliation forum, and I choose to go before a conciliation forum, or I am the complainant, I want to go before the conciliation forum, there is an acceptance of the 50%. So that there is a ratio of 50-50% where the disputes are going before the conciliation forum. But the important thing is that the ratio, success ratio of the conciliation forum is 90%. This is the MahaRERA statistic. Apart from that, so far, approximately 1200 matters are resolved through conciliation forum in the MahaRERA, and approximately 130 matters are in process in the conciliation forum. So this is the data of the MahaRERA. If we see the UP RERA, there are two conciliation forum. One is Noida, another is in Lucknow. And who are the part of this conciliation forum? So from the builder side, the Credai, Naredco, they are the part of the conciliation forum. If see in the MahaRERA, there is a Grahak Gram Panchayat is the part of the conciliation forum. In the UP RERA, again the buyer association is there in the conciliation forum. Now if we see the ratio that how the conciliation forum is working in the UP RERA, the 80% matters are resolved through the conciliation forum, and approximately 1900 matters are resolved. And if we see in terms of the value, approximately 345 crores rupees property disputes are resolved through the conciliation forum. So this is a little bit background about the conciliation forum. And if we go and practical part, as Nipunji correctly said, when we refer the provision, it says that the conciliation can be happen through the mutual consent of the parties only, right? So the same thing when we go for the conciliation forum, if I am a complainant, I want to go before the conciliation forum, I have to go and register myself on the RERA portal. I have to say that I want to go for before the conciliation forum. If the opposite party accept, then only the conciliation forum matter would be proceeded. If the other party do not proceed, obviously there would be no conciliation forum matter, right? So this is the first important thing. Apart from that also, what RERA has done, suppose I have filed the complaint under section 31 of the RERA Act. Now during the proceeding, the hearing has started. Even after the filing of the complaint, if I want to choose and I want to go before the conciliation forum, there is an option that yes, you can go before the conciliation forum. So when I first directly go to the conciliation forum, second option I have that after the filing, I can choose whether I want to go and mutually settle the dispute through conciliation forum or not. So this is the concept. Similarly, in the December 2018, UP-RERA has also come with the circular and the conciliation forum. They are also proceeding in the same manner that how the conciliation forum will be work. Another important thing is that in the conciliation forum, but according to my understanding, the observation I made, the dispute are resolved very quickly after the hearing starts. No doubt, once the starting is a very difficult, but once the matter starts, it is resolved very quickly, and the fees is very nominal. It is 1,000 rupees. So when I go for the conciliation forum, that information would directly go to the third party through email and through the SMS. And when the third party gives the confirmation on the email that they want to go for a conciliation forum, obviously then proceeding would be started. The other procedure is like the same, what they have to give their information regarding the dispute, what dispute they are having, what are the facts of the case. These are the information they have to write when they are filing any matter with the conciliation forum. So this is about the conciliation forum, which is provided by the UP-RERA and RERA by exercising the power under section 32 subsection G. Apart from that conciliation forum, when the conciliation forum starts, when both the parties agrees, then they sign a mutual understanding that they have come with the settlement, and that would be intimated to both the parties. Now the question arises that what happen if the any party who is agreed on the conciliation terms, and if they do not execute that, again the matter would be go under the RERA. So the only negative part, if we say, then suppose the other parties do not perform their obligation, which whatever they have agreed in the conciliation forum, then the time process to resolve the dispute, that would increase. So that is the only, I can say it is a one negative part, but not on because if you see the ratio, 90% or 80% successful ratio is there, then it is a ignorable things. So how this is how the conciliation forum is working. And Nikunji, anything apart from that you want to like to add me?
No, I think this is fine. We just wanted to tell the audience that there is a possibility of other means and ways to also redress the grievances. So arbitration is there, conciliation is there, but because most of the participants are not aware about other forums, so I thought that we should also give them insight. Because interestingly, Pan India, only the Maharashtra RERA authority
And
has
UP-RERA also.
UP RERA also. Okay. So only two authorities have come out with this unique concept of closing the complaints at the outset. So this
And
is
the
a
important part is that there is a success ratio is very high. Even though the parties in the other states, the other RERA authority has not implemented this thing, that is we don't know. But if we look out the static data, then the success ratio is very high. So I think that should be implemented pan India.
Sir, this arbitration forum is regulated by RERA authorities.
Yeah, this conciliation forum is regulated by the RERA authority because they are exercising the power given under section 32.
So it is
So
not an
if you-
arbitration panel, it is a conciliatory panel.
It is a conciliation. That's why they have given the conciliation.
conciliated.
Yeah, so if we read a section 32, then you will come to know about what they have, I will read that para, what section 32G says. So 36(2)G says the authority to measure, to facilitate amicable conciliation of the dispute between the promoter and the allottees through dispute settlement forums set up by the consumer or the promoter association. So the parties are from the consumer association and from the promoter. So that's why from promoter association like NAREDCO is there, CREDA is there. Like if you see in the MahaRERA, then Gram Grahak Panchayat is there. So that is from the consumer side. In UP-RERA, another consumer associations are there. So they are the part of that conciliation forum.
So there are three questions. Should I read it, sir?
Please.
Yeah. Suppose there is a compounding wall destroyed due to rain or wind defects in construction of compounding wall. Is it covered under structural defects under section 14, subsection 3?
Nipunji, would you give answer?
Please, Vidlai.
So I think this is not a structural defect. This is the compounding wall, which is not a part of the structural defect. So structural defect is if technically in a simple sense, if we see what is the building is standing on the structure. So that structure level is defined by the architect. So अगर हम इसको सिंपल लैंग्वेज में बोले तो फाउंडेशन क्या है, उसका स्ट्रक्चर क्या है जिसपे वो बिल्डिंग खड़ा है. तो अगर वो स्ट्रक्चर में डिफेक्ट, कंपाउंडिंग वाल स्ट्रक्चर पे नहीं खड़ा है, स्ट्रक्चर पे अगर हम देखें तो पूरा बिल्डिंग खड़ा है. सो अकॉर्डिंग टू माय व्यू and my understanding, that would be not a part of the structure defect.
Okay, so the possession is offered after significant delay over 5 years and without OC. Can one take possession and also claim the interest and the damages for delay? How do we approach under RERA or other laws?
See, to be frankly, one of the decision which is taken by the MahaRERA authority, in which the possession was given or possession was taken by the customer without OC, and the MahaRERA has started the prosecution against the landowner, against the promoter, and against the allottee also. So there is one judgment. So without occupancy certificate, if you are taking a possession, it is illegal, even as per the municipal corporations rules and the MOFA rules also. So if you are taking a possession without occupancy certificate, so RERA authority has given the direction to the municipal corporation to start the action, to take the action against the promoter, landowner, who was a co-developer, and the allottees also. So there is one judgment of the MahaRERA authority. So technically, if somebody asks the question whether possession should be taken, then it should not be taken because there is a judgment in which it was accepted that the without OC the possession was taken over. What is another question?
Yes. Can the aggrieved party refuse to accept the award or during the continuation proceeding alleging the arbitrator is biased, not taking the cognizance some facts?
No, I'm not getting. No, what was the part?
Yes.
This was the part, one of the question of the OC. Another related question was there.
Achha, okay, right. Can one take possession and also claim the interest and damages for delay? How do we approach RERA or other laws?
Interest can be, claimed at any time. So there is a judgment of the Honorable High Court also, the MahaRERA Appellate Tribunal also. Even the OC is received, you have taken possession. Even the Honorable Supreme Court also says that the right of allottee in respect of the claiming the interest is unqualified. So even they have taken a possession, they can claim interest. Even the OC is also received, then claim the interest. I think in the New Tech Developer judgment also it is written that the right of allottee is unqualified.
So even if the allottee has taken the possession and received the OC, he can claim for damages.
Yes. Nikunj, you want to add something?
No, I think you have already taken the query in more extensive way.
There's one more question. When RERA authority ban
In fact,
promoters,
Yuriji, I think
yes,
that people are asking us the RERA law. Nobody is
yes,
asking us any question on what will happen if arbitration is there. Can I go to RERA or come back to RERA? Because our today's
a
topic is
topic.
very interesting.
Hmm.
RERA Act, any which ways, is a very good subject.
Very.
But
Hmm.
our topic today is interplay with them. So I suggest that participants please apply your mind whether arbitration versus RERA you have any queries, because if that is a query, then it will be fruitful for you to achieve faster solution in a better way. Yeah, please go on, Mayuri.
Yes. When RERA authority ban promoters, how a buyer gets their flat register since company and promoters are banned. So this is also a RERA question.
Oh, so there is as such. If you read the RERA law, there is no section, no provisions where they say you can ban somebody. Now, I don't know what the contestant means for the banning, but yes, we can tell you that now some of the RERA authorities have
Nikunj,
come out with a list of defaulters.
I will add into that. He
Yes,
might be talking about the section 7 where the revocation of
yes,
registration after the
I
revocation.
was, yes, I was also coming on to that only. That suppose some builders have not done compliances. So now, just like Maharashtra RERA also came out with the list, UP RERA also came out with the list that these all are defaulting promoters. So that gives us an idea that these promoters, if they have any other project, we should also not buy any project particular property or plots from them. Then second is, suppose the registration was given, but it was revoked or cancelled because of some negligence. So let's say there is some title dispute which was known to the promoter, he did not disclose. So immediately they would cancel the registration. Now in one of the case we were advising, there was no safety measures during the construction. I think two or three laborers died because of falling from, I think, fourth or fifth floor. Now, in that case, immediately RERA suspended their certificate. So point is that if there is a cancellation or revocation or defaulting, these particular terminologies are not alien to RERA law. But technically saying banned or blacklisted, there is no terminology under RERA law. So there cannot be something which is banned or you see blacklisted. Ultimately, they can only give a list under a particular section. Though sometimes, media always writes some fancy words. They are not in the law. So probably he must have read something in the media and he's asking.
Okay, thank you, sir.
So I think we have taken up the queries. Now I think just to close the jurisprudence issue, we'll just touch upon some of the case laws which otherwise are important, maybe not specifically on arbitration versus RERA, but these provisions are somewhat important if you appear whether before arbitral tribunal or RERA authorities. So I'll just compile some of the judgments which might be important. So I've seen many of the professionals when they appear before authorities, any authority, whether it will be arbitral tribunal or RERA authorities, they generally do not put submissions on record. So suppose I am citing 10 authorities. So I am citing 10 judgments of, let's say, Supreme Court or High Court or RERA Appellate Tribunal, any court I am citing. Now, suppose those case laws are not part of my submission, they will not be taken on record or not be discussed in the judgment, in the final judgment given by the authority. But if I have placed it on record, maybe by way of a written submission, some courts call it pushish, some courts call it memo, whatever mode you put it on record so that when you argue, you may argue 10 things. But what is retaining in the mind of judges, that will only come in the final order. Now, if the judges do not consider the case laws cited by you, they do not discuss it, they do not differentiate it, or they do not rely on it, then it is also to be treated as contempt. This is a very interesting judgment of Bombay High Court in the case of Yogesh Vaman versus Vikram Jadhav. Very famous case which you can all can use before any authority, any judicial authority. That if you are citing case laws and that is not discussed in the final order, then it is a judicial contempt even on the judges. So this is very important case law. Then this is again a part of jurisprudence. So I'll tell you both the examples. So Real Estate Appellate Tribunal, we had also filed a PIL saying that the judges are not as per the quorum. So the law says there has to be judges to hear it. There cannot be a single judge. There has to be a quorum. Now the law also provides that judicial members should be in majority, and one judicial, one technical has to be there mandatorily. However, some laws also says that two judicial, one technical can be there. Some says one judicial, one technical can be there. As far as our RERA appellate tribunal is concerned, there has to be two judicial, one technical member. But this applies across all the laws. Now, here if you compare it with the arbitral tribunal, again in arbitral tribunal, there can be arbitrator, but again the arbitral tribunal, the arbitrator has to be in odd number. If they are equal in number, then there will be a chances of tie. So here there is a contrast between RERA law as well as the arbitration law, where a single judge in arbitration can also be considered to be a proper tribunal, whereas let's say in the appellate tribunal under RERA law, it has to be 3 judges. Another important aspect is that when the person is referring to arbitration, one of the, let's say, builder has referred to arbitration, you are appearing before arbitrator, and there you think that it is not correct that this arbitration is enforced. And let's say your allegations are of fraud. It could be of fraud, like multiple selling of lots, which happens. So when you had booked, you have made the payment. Let's say it was for A302. Then when you actually went there, it was sold to somebody else and he said that you take 202. So this is a fraud or mis-selling. So in that particular case, when a fraud is committed on you, even if there was an arbitration clause and arbitration is enforced, you can definitely object to the arbitration by filing an appropriate preliminary objection, or sometimes you can also file an application and get an order by the arbitral tribunal that sorry, the exercise of arbitration is incorrect in such a situation. So if you want to object to a particular jurisdiction, whether it is arbitration, whether it is RERA, or whether for that sake any other case, if you want to object anything, prima facie, at the level of preliminary initiation, please make sure you file a preliminary objection. Now, the authorities cannot say that we will decide your preliminary objection and final objections together. That is again very important. On the lines of this, we got a RERA order, matter of RERA Gujarat. We got an order from Gujarat High Court, wherein it was directed that the preliminary objection should be decided and in accordance with whatever is the principles of natural justice and civil court powers. So if suppose I am objecting, let's say there was a case wherein the customer said that I have paid 100 rupees in cash and 50 rupees in check. So this is a very generic and a normal case which normally comes up. Now in that case, if he is saying that I have paid cash, there is no evidence that he has paid in cash, then sorry, court cannot take cognizance of the cash component. In fact, it is the other way around. The onus on the authority, let's say in this particular case, it's a RERA authority. The onus on the authority is to make a complaint to the appropriate authority. It could be Enforcement Directorate, it could be Income Tax Department, that somebody is coming with a complaint on affidavit that I have paid so much cash. So cash is not permitted, then he cannot pay. So therefore, that is illegal. So that is one. Second is, suppose you are saying that a matter is pending. Suppose I am now talking from the aspect of builder. Suppose the matter is pending already in arbitration and the allottee goes and files under RERA. And your already arbitration proceedings are going on. Let's say they are in the intermediate stage or maybe final hearing. then he cannot come and switch over the forum. So then you can very well object at the preliminary stage. It is not maintainable before RERA authority because arbitration has already been enforced and other side submitted to the arbitration proceedings. So once somebody has accepted, then they cannot challenge it. Then one more aspect, sometimes, as I told you, even on the advertisement side or a remedy in rem. So when there is a remedy in personam, yes, arbitration can be there. But let's say you are having a situation when the remedy is in rem. So there is a misleading advertisement, false advertisement, and you are agreed only by the advertisement, you are not even an allottee. Because obviously you must have pulled out the money if you have come to know there is a misleading ad. So in that particular situation, it is not arbitrable. And therefore, you can go to the court, that is in this case, RERA authority, to get the penalty imposed on that particular builder. Because sometimes this also argument is taken, then there is no agreement between the complainant and the builder. So even if there is no agreement, even then you can go under RERA because RERA only says any violation of RERA Act has to be brought to the notice. Nothing more than that. Now, recently there is a judgment of Kerala High Court in the matter of NBCC versus Joshi Varghese, though I have already completed it in my deliberation, but this is the citation, which says if there is a lower interest rate than prescribed under RERA, can that be argued? So, if the RERA provides X rate of interest and builder is providing you X minus something, then the RERA prescribed interest rate will have to be provided. You cannot agree on something which is contradictory to law. There is no estoppel to statute. I think I have already taken this, that recently this issue has come up of members in the tribunal. So now RERA Appellate Tribunal needs to have 3 members, chairperson and 2 members, whom which one should be a technical and 2 should be judicial members. Supreme Court, again, in one of the very interesting case, so which we were discussing, that consumer and RERA can go parallelly. Interesting case came before the Supreme Court that in case of insolvency, where the company does not have funds to pay and the company goes under insolvency, whether first RERA versus insolvency, who would win? So both the laws have overriding provision. Insolvency under Section 238 has an overriding effect and Section 89 of RERA Act has an overriding effect. So the question came before Supreme Court, which should prevail? So Supreme Court said that somebody will only come to insolvency when they have exhausted the remedy under other law, and insolvency law, being a code in itself, will override on RERA. So RERA and consumer both will go parallelly, but in case of RERA versus IBC, IBC will go and RERA will be overridden. So IBC will override when there is a conflict between IBC and RERA. This is what the PUCI judgment of Supreme Court says. You can refer to this judgment in detail, and this has been holding fit quite a few times now. Then recently in the case of Ansal matter, if somebody has obtained a RERA order, it is as good as decree, civil court decree. To recover the amount, you can go for execution of that civil court decree, just like you go to civil court for execution. Some authorities have in-house recovery execution. Sometimes you have to go to magistrate or district magistrate, as the case may be. Now here the question came that whether on the basis of decree, I can go to insolvency law and say there is a default, see it is adjudicated. So court said that just to execute a decree, you cannot come to the NCLT with regard to home buyers, and you will have a proper recourse under RERA law. So for one home buyer, you cannot push the whole company into insolvency. So court has gone to that extent to understand the importance of RERA orders, and also they have put in place that RERA would be given supremacy until and unless the situation comes that the company does not have assets. Only then insolvency should be triggered. Now, recently there have been cases where, let's say, number of projects are there in the company, at least some few projects have gone under maybe liabilities or excess, or because of some reason could not be done on time. Now, in those cases, Supreme Court has allowed, and recently in Supratech also it has been allowed, that that particular project can be completed. Number one, if the association of allottees take it over and wants to complete on their own. Second, if the government wants to take it up and complete on their own, like Noida Authority, like Maharashtra Authority, any authority which wants to take it over and complete it, they can very well do so. In fact, somebody who has paid the money and sale deed was not done, and in the intermittent time, the company goes bankrupt. In that particular situation, also, the sale deed can be executed by the court order. In one of the cases of Gujarat RERA, we saw that the landowner refused to sign the sale deed because there was a dispute between landowner and the developer. However, the home buyer had already paid, but execution of sale deed could not happen. And the matter went to RERA, and RERA directed the landowner to sign it. Even then, the landowner refused to do it. Then they appointed a RERA officer who was authorized by court order to execute sale deed on behalf of the landowner. So by court order, these all things are possible, which otherwise in normal situation may not be possible. So I think I have broadly covered all this. We have already covered these things which I had been deliberating. So I'll just share my contact details and email ID. If there are any further queries, I can take it over. So Mayuri ji, if there are any further queries, we can take it up.
So there is one question, whether one can go to RERA after accepting arbitration. I think Mahadev sir had answered this, that it will take longer time, right?
No, I had also answered it.
Yes.
So that Bombay High Court judgment citation which I had given, once you accepted arbitration, then you can't go for RERA.
Okay. Can lower interest granted under arbitration? So this is the question.
Can lower interest rate be granted under arbitration?
Arbitration.
So that also I covered, that if your arbitration agreement itself is providing for lower interest rate and it was pre-RERA, then obviously you will have to go by that. If it is post-RERA, and if one of the parties is able to demonstrate it was under pressure, then obviously statutory rate of interest will have to be given. I gave you the Kerala High Court judgment also, no, NBCC. It is there in my PPT.
Yes, sir. Sir, there's one question from my side. Sir,
Yes.
is this, if the developing authority is like state government, like state government development authorities, can matlab cases can be filed against them?
Yes, 100%. In fact, now the law is very clear and multiple orders have come as far as Maharashtra, Gujarat, Tamil Nadu, and I think Kerala also. At least 4 states I can say, even the High Court orders have come, wherein it has been held that RERA does not exempt governmental authorities. So whether it is registration, whether it is agreements, whether it is delayed possession, everything applies to them as it is, until and unless. So they have the power. State government has the power to exempt some projects. Only project-wise the exemption can be there, and that has to be notified in the official gazette of the state. As of now, I don't think so any notification has come, but otherwise everything is covered. It doesn't mean that you are a government authority, so you will have your way. No, that is not permissible.
And the housing schemes by government,
Yes,
all applicable.
covered. In fact, the famous case in the Consumer Protection Act is of DDA only, Delhi Development Authority. The first case in which Supreme Court gave the guideline with regard to interest, with regard to delayed possession, was of DDA only. So that is always covered.
Right. There are no more questions as such. We'll wait for some time.
Okay.
There was one more question is, can we go to RERA if arbitration award is not acceptable?
So If I play and I lose, I say that the match was itself bad. It can't be
Yes.
done. If you have already joined a proceeding, you have taken participation, then you cannot challenge this proceeding itself is wrong. And I also told that preliminary objections, if there are any, you can take it there. In fact, now the Arbitration Act also has a very detailed schedule. So let me give you a very interesting example. So suppose two parties appoint me as an arbitrator. Now see, I have to disclose if one of the parties was my client, is my client, in my personal capacity, in my professional capacity. If I am related to any of the parties, I will have to recuse myself. If suppose for one of the parties I have handled three or more arbitrations, so if there are three arbitrations, then I am immediately being disqualified. It happened in the famous case again decided by Bombay High Court in the matter of Tata Capital, where one of the arbitrator was on the panel and he had decided, I think, more than 1,500 arbitration. So obviously, when I am on the panel of one of the entities, and I would be biased towards that. So that is also gone. In fact, the ONGC, IOCL, all these government PSU companies, they had a clause that if there is a dispute with the contractor, there will be an arbitration, and arbitration would be done by a general manager or deputy general manager of the company. So if one of the parties appointing an arbitrator from their own company, it is immediately disqualified. So complete arbitration goes away. So that such grounds which ultimately render the arbitration proceedings as perverse, bad in law, void ab initio, that is a different situation. But just because you have taken participation and the order does not come in favor, you say the court is wrong. That is not acceptable.
Limitation period for filing case before RERA or seeking remedy under RERA.
So there are different limitations for different provisions. Like, for example, if there is a structural defect, I told you it is 5 years. So that 5 years has been prescribed under the RERA law itself. Now, what could be the other ground? So suppose I have been given a delayed possession. So I was supposed to be given, let's say, possession in 2021, and I had been given possession in 2023. Now, what would be my cause of action? Only when the possession is given. So you can, at the last, from 23, within 3 years, file a case, because there is no provision of prescribing limitation under RERA law for this particular case. So you will have to go by the Limitation Act 1963, which says broadly 3 years from the date of cause of action for in such civil wrong. So that you can always do. I think if there are no further questions, we can wrap it up, Mayuri ji.
Yes, sir. Yes, sir. So there are no questions, sir. And it was a wonderful session and to listen from such an eminent speaker. And we have come to know that there is a conciliation forum which is regulated by RERA, and there is alternate dispute mechanism available, and which has a very high rate of success rate of 90%. And 2 states have already implemented this, Maharashtra and UP government. And our members should take note of this arbitration clause in the RERA agreements of their clients, and suggest about this alternative dispute resolution. And we have gone through some cases and the laws, the IBC code, and it we sum up with the wonderful knowledge. Thank you so much, sir. Thank you for your words, and thank you for your time. And I, on behalf of the committee, wishes you good luck and for the future future talks. Thank you so much.
Thank you very much, committee and Mayuri ji.
Thank you.